in plaintiff's favor be reversed, and that this case be remanded with instructions to enter summary judgment in favor of Metro. The trial court erred in two important ways. First, the trial court found that the director of schools did not have the authority to delegate the responsibility to non-renew probationary teachers or non-tenured teachers. Second, the trial court found that based on that, the continuing contract law, or section 495409, gave the plaintiff a private right of action in this case. Of course, it is Metro's position that both of those rulings were in error. This case involves relatively few facts, and substantially all of them are not under dispute.
If I may, to clarify something, this case does not involve a tenured teacher's rights. Is that correct? That is correct, Your Honor. Even though the plaintiff was a tenured teacher, she was not during the operative time at issue here.
I don't know about plaintiff's tenure status now. She was not at the operative time. That's correct.
Thank you. Okay.
This is the case of a probationary employee, a non-tenured teacher.
Okay. Thank you.
As I was saying, at the end of the 2017-2018 school year, the director of schools delegated the responsibility to his executive director of human resources and the executive principals the job to review the budgetary and staffing needs of each individual school, and if necessary, to decide which probationary employees, non-tenured teachers, needed to be non-renewed. To that end, Ms. Lee Peary was contacted by her principal and was notified that her contract would not be renewed for the upcoming school year. A few days later, the director presented to the school board and notified them that the decisions regarding non-renewals had been made and that the notices were being sent out. And then on May 30th, 2018, the notice was sent to Ms. Lee Peary, notifying her that she would not be renewed for the upcoming school year. Two very important facts about that notice. First, it is undisputed that Ms. Lee Peary received that notice. And second, it's undisputed that the notice was timely under the statute. That should then end the analysis under the continuing contract law. In a trio of cases, let me back up just a moment. Plaintiff's argument boils down to two arguments. First, again, that the director had no authority to delegate the duties. And second, because he lacked the authority to delegate those duties, that the decision to non-renew, and then therefore the notice of non-renewal, lacked effect. It was ineffective. And that's how we sort of backdoor into the continuing contract law. Of course, I think there are two major flaws with that. First, regarding the ability to delegate, the legislature was clear that they were empowering the director as the CEO, the executive of the school system, and given broad discretion to execute the policy of the school board the way that she sees fit. And I think we'll demonstrate how the legislature further contemplated that delegation would, of course, be a part of that responsibility. Second, this recent trio of cases discusses the private right of action, which is granted by the continuing contract law. And that is, of course, Dallas v. Shelby County Board of Education from this court from 2019. Then we have Mosby v. Fayette County Board of Education from this court in 2020, and Parker v. Lowry, a little bit older case from this court in 2013. Ultimately, those cases stand for the fact that there's no right of judicial review regarding the decision, the sort of who, what, when, where, and how of a non-renewal decision, so long as the notice is timely. And again, in this case, there's no dispute. Ms. Lee Peary received notice, and the notice was timely under the statute.
The notice just needs to be before the end of the school year.
That's correct, Your Honor. And the purpose of that is to give non-tenured teachers a chance to plan for the next school year. Oftentimes they apply for other open jobs within that school district, or they go outside the school district. In any event, the purpose of the law is to clear up any controversy and to provide these teachers with sufficient time to plan for next school year. And that's why its objectives, its purpose, are fulfilled with timely notice. And it's also why this court has clearly spoken a number of times and suggested that beyond that, there's no protections. There are no right of judicial review of the who, what, how was a decision made, why was it made. Those protections don't exist under the continuing contract law. And for that reason, that's where this analysis should end. The Dallas case, again, said that the timely notice of non-renewal is the essence of the thing to be accomplished by the continuing contract law, by 49.5.409. It is essentially the sole protection. That's the Dallas case. And
so had a notice not been sent at all, but the system intended to send, or maybe sent one late, there wouldn't be an automatic renewal of the contract in that case?
No, I think there would be. I think that is the Snell case. So if the notice is sent late or not sent at all, then the purpose, the protection, the sole protection of the continuing contract law is not fulfilled. The teacher was never on notice that she wouldn't be renewed. And so that's when the Snell case kicks in and but
in this situation, you step further in that the teacher wasn't paid, obviously, for the follow-up school year. So it seemed like to me there would be a contract claim. You're saying, well, I appreciate the essence of the statute is to give notice and timely notice, but wouldn't there be a contract claim if there was no payment made on top of that?
Well, I think the contract only exists if timely notice isn't sent.
Okay.
And that's
the issue here, right?
That's the issue here. That's the continuing contract law. The contract only continues because these teachers serve on year-to-year contracts, one-year terms, and they're sort of unsigned free agents at the end of that term if they receive that notice. And that's what happened in this case. Ms. Lee Peary received her notice. Her contract came to an end, was fulfilled, and then there was no new contract moving forward. So we can't have a breach of contract case without that new contract. And this court has spoken a number of times and suggested that we don't pry open the process of the decision to suggest that we should be able to go in and look about and see who made the decision, how was it made, what did they consider. Those protections used to exist, but the legislature has spoken clearly a number of times and removed a right to an appeal, a right to a hearing, and removed prior authority of the school board and just made this distinctly the administration's responsibility. So I think that's really where the analysis should end in this case. There's no private right of action. There was no contract. End of story. But if we do get to the director's ability to delegate, I think the legislature has spoken clearly. In 1992, the Educational Improvement Act came about, and the purpose of that was to create these school systems in the image of a big company, of a corporation. And at the head of that corporation, charged with executing policy and being the administrative and sort of executive arm of the school system was the director. The director, of course, remains answerable to the board, but they're given broad discretion. Again, to execute policy, not to make policy. And to that end, the legislature spoke to the school board in Tennessee Code Annotated 492301B1, and that's a list of 37 duties. And they spoke to the school board and said, assign these duties to the director, to the administration, and take a hands-off approach. Allow the director to ensure the efficient operation of the school system, and don't get involved in those sort of administrative and executive decisions.
So help me understand how Dillon's rule works when you have this big enumeration of duties of the director of schools.
Sure. Thank you, Judge McBride. I think Dillon's rule, plaintiff would suggest that Dillon's rule holds that if there's no specific language in the statute that says the director may delegate this duty, that Dillon's rule says authority doesn't exist. But I think it's broader than that. Actually, I know it's broader than that. In Southern Constructors case out of the Supreme Court from 2001, that court said that the necessarily implied or necessarily incident powers are expressly granted. Also, powers which are absolutely essential to the declared objectives, and purposes of the corporation. That goes to, again, what is the purpose of the Educational Improvement Act? What are the purpose of these statutes? And it's to empower the director and the administration to make these decisions and to take a hands-off approach. So I think even if we're applying Dillon's rule to the director rather than to the legislature or to the school board, I think the director's ability to delegate is present in the statute. There's also in section HH of that list of 37 duties. I see I've run out of time. If I may have the court's indulgence for a moment.
Finish your comment.
Section HH suggests that all actions of the directors or their designees shall be consistent with existing board policies, et cetera. I think the language "or their designees" is an express contemplation of the fact that the director must, of course, be able to delegate some of these duties. A list of 37 duties that the director, him or herself, must accomplish, again, personally and individually without delegating, seems a ridiculous, an absurd burden, particularly in light of the fact that the legislature recognizes it.
All right, thank you, Mr. Puckett. You'll have time on rebuttal. Mr. Colbert. Good morning, sir. I've always wanted to ask you, since Stephen Colbert became so popular, have you considered changing the pronunciation of your name?
No, Your Honor. I think being born and raised here in Nashville, that just seems kind of pretentious to me.
I think it's a good decision. I just want you to know. Okay.
Your Honor, Rick Colbert and I represent Brenda Lee Peary. The issue in this case is whether a notice of non-renewal sent under the continuing contract law is effective if the underlying decision to non-renew was made by somebody who had no authority to make it. Teachers are employed in Tennessee on one-year renewable one-year contracts, and that's language from this court's opinion in Cannon County Board of Education versus Wade. It's 2008 unpublished opinion. Under the continuing contract law, which was passed in 1943, actually predated the tenure law by 8 years, so it was the first real protection that was given to teachers in their employment. But under that law, these contracts renew automatically from year to year unless the director of schools, back then it was the board, affirmatively non-renews the teacher by whatever the statutory deadline may be. That deadline has changed over the years. Originally it was April 15, it moved to May 15. Now it's 5 days after the last day students attend school. But as the name of the statute signifies, and I know there's some language in case maybe Dallas that says that the notice of non-renewal is the essence of the statute, but the statute is the continuing contract law. And we believe that as the name of the statute signifies, it's the automatic renewal of a teacher's employment from year to year that's the essence of the statute. And the provision for notices of non-renewal to stop that automatic renewal is the exception.
What gets me about this case is, I mean, both sides here seem to describe the Education Improvement Act as adopting this corporate model for governance. It strikes me this is a very strange corporation where the president personally has to make all these numerous decisions outlined in the statute. That's not how corporations work. There's a lot of delegations going on. And so if I am to accept your interpretation of the statute as the correct one, that the director of school has to be personally involved in that, then my next question is, well, how involved? I mean, does the corporation, was it enough to Mr. Joseph or Dr. Joseph to say, flip a coin on these and that's enough? Or, I mean, where do we go from there? It just seems like you could take this to, a level of absurdity, if you see what I'm saying.
Well, Your Honor, if you take every one of those 37 items and say the director must personally do every one of these things, it probably would come out a little bit absurd. There's one of the duties is that he must keep bound books containing minutes of the board. Certainly he can delegate that. But I think if you look at the law on delegation, and we talked about this in our brief. This gets back to
the judgment. Where is judgment involved?
Right. This gets back to the old City of Rockwood case. It's almost a century old now, but it's been followed as recently as 2018 by the Sixth Circuit in the Kelly case that came out of Shelby County. But the standard is that duties of public officials that require judgment and discretion are not delegable unless specific authority is given by the legislature for those to be delegated. Duties that are more ministerial or administrative those can be delegated without an express authorization to delegate them. This was a duty that required judgment and discretion. There's no dispute about that. There were two witnesses whose depositions are in the record from Metro, and they both acknowledged that the non-renewal of teachers is a duty that requires judgment and discretion. Now, what does the director have to do? I submit to you he could have done something as easy as what boards of education used to do before the Education Improvement Act was passed, because back then, boards of education prior to, well, really, the act was implemented between 92 and 98 as superintendents' elected terms expired. But it was passed in 92, and prior to that, boards of education had all of the personnel responsibility. They had all of it. Directors had none. The director could only make recommendations to the board. And so what would happen on non-renewals of non-tenured teachers back then is at school boards meetings in early April, before what was then an April 15 deadline, the director would come in with a list of teachers that he recommended be non-renewed, and the board would approve it. Now, the board had the option, because it was the board's decision, they had the option to pluck a teacher out of that list if they wanted to and say, no, we want to renew this teacher. Because that was their decision to make. But that's how it went. There would be a long list of teachers, and it would be a recommendation from the director, and the board would approve it.
Well, could we say that happened in this case when Dr. Joseph made his pronouncement on May 25th? Letters are going out? I mean,
no, Your Honor, I don't think we can, because if you look at that document, it's a 16, 18-page document that's a weekly report that came from the superintendent's office to the board about all the things going on in the school system. But in that, there was a section on personnel, and it wasn't from Dr. Joseph, who was the director of schools. It was from Deborah Story, who was the head of HR for the school system, and she gave this report. That wasn't really, it was on Dr. Joseph's letterhead, but that was really Deborah Story's report to the board, and the testimony from Kay Stafford, who worked in human resources for the school system, was that Dr. Joseph had no involvement whatsoever in the decision to non-renew any of the 30 to 40 teachers that were non-renewed that year. I mean, that's undisputed. That's an undisputed fact that he had no involvement in that decision. So this is, the fact that this can't be delegated to a subordinate is not unique to the non-renewal decision. In keeping with the distinction between duties that require judgment and discretion versus those that are ministerial, the Sixth Circuit in the Kelly case said that the dismissal of teachers and a reduction in force cannot be delegated by the director of schools to school principals. It couldn't even be delegated by the board to the director. In the Randall versus Hankins case and the Lee versus Franklin Special School District case, this court held that the determination of a teacher's fitness for reemployment after she's been laid off couldn't be delegated by the director to school principals. That determination of fitness had to be made by the director. And even in Parker versus Lowry, which is one of the cases Metro relies on, there's an interesting passage, and I think I attached the Lexis version of that case to my brief, and it's at *11, but in the Lexis version. But the Tennessee Organization of School Superintendents, which is, I mean, there's legislative mention of that organization as an organization representing school superintendents all across the state. They filed an amicus brief in that case, and according to this court's opinion, TOSS said in their amicus brief that the non-renewal of a non-tenured teacher was a non-delegable duty of the director of schools. That was the position of the Tennessee Organization of School Superintendents just 10 years ago in the Parker versus Lowry case. So it's not completely novel that there would be some duties that the director has that can't be delegated. Since the director was indisputably uninvolved in this decision, the notice of the decision was ineffective. Notice of an invalid decision is no more effective than no notice at all. If a valid decision was not made, the notice means nothing. And Ms. Peary, therefore,
Does the director, and I'm sorry to interrupt, Mr. Colbert, but the director also have to sign this letter to make it effective, or was it enough, would it have been enough for him to be involved in the decision?
Your Honor, I think it would have been enough for him to be involved in the decision. I think the signing of the continuing contract law says the letter has to be sent by the board or the director as appropriate. And I think that was thrown in there in '92 because there was this period of time where in some cases it was still the board's responsibility, and some it was becoming the director's responsibility. That statute says the notice has to come from the board or the director, but that clearly is a ministerial function or an administrative function, sending notice. It's not the decision-making function. That's just the sending of the notice. So. Yeah, and I think I've said this in our brief, and I feel certain I said it before Chancellor Lau when we argued the case. If the only issue was that the letter came from Sharon Pertiller instead of from the director, we wouldn't be here. But the problem is it was the decision itself that the director was not involved in. Ms. Peary, therefore, we believe, had a right of action for breach of her continuing contract of employment consistent with the Snell versus Brothers decision from the Tennessee Supreme Court in 1975. Now I understand Metro relies on Dallas and Mosby and the Parker versus Lowry case to argue that there's no right to judicial review as long as the notice of non-renewal is timely, but in all of those cases, the decision itself to dismiss the teacher was made by the director, the person who had the authority to make the decision. There was no question about whether the decision was a lawfully authorized decision. None of those cases suggest that a decision to non-renew by someone with no authority is immune from challenge as long as notice from that person with no authority is timely. If that were the standard, and I know I got criticized for this a little bit for saying it in my brief, but if that were the standard, then you could have non-renewal decisions made. You could have a director delegating to school custodians or school cafeteria workers or bus drivers or the school secretary the authority to non-renew a teacher. And I don't think anybody would suggest, I don't think even Metro would suggest that that would be an appropriate delegation of authority. Metro has argued, and I'm using the code sections as they appear in the code now. They've been redone a little bit over the last few years because there were a couple of subsections in 49.2301 that were taken out of that statute. But in what is now 49.2301B1FF, there's a provision that gives the director authority, according to Metro, that gives the director authority to delegate all of his duties to anyone he pleases because it makes some reference to designees. But that subsection of the statute just says that when a director or a designee acts, they must do so consistent with board policies, rules, contracts, regulations. It is not an authorization to delegate. It's a directive about how those acting must take those actions. The most that can be said about that statutory subsection is that it recognizes that some duties of the director are indeed ministerial and may be appropriate for delegation, and if carried out by others, have to be carried out consistent with board policy. For example, the sending of the notice of non-renewal.
Mr. Colbert, the recodification, was the substance of the statute changed or just the codification?
The substance was not changed, Your Honor, as far as the parts we're here about now. There were a couple of those duties that were removed, and that meant renumbering or relettering of the rest of them.
But what we're dealing with, the substance of the law is not changed.
That's correct. I do want to point out something else about that statute before my time runs out, Your Honor. There is a provision that was added in 2007, subsection B1HH, and it says the director may authorize each principal to make staffing decisions regarding administrative personnel. It says nothing about teachers. It says administrative personnel. And if the legislature can't be presumed to add meaningless words to a statute, if the power to delegate already existed broadly, there would have been no reason to put that provision in the statute. And also under the maxim expressio unius est exclusio alterius, I think I spit that out properly. The expression of one thing implies the exclusion of others. If the legislature had wanted to include staffing decisions about teachers in that authorization, it would have. The fact that teachers aren't mentioned there is an indication the legislature did not intend to mention them. And that's consistent with the subsequent statute on principals' duties, which only gives principals the power to make recommendations on personnel. Your Honor, I believe my time is up.
Any questions? Hearing none. Thank you, Mr. Colbert.
Thank you.
Mr. Puckett, you have rebuttal.
Just a few brief comments, Your Honor. First, I want to hit back a little bit on this notion that the director had no involvement whatsoever. I think that the undisputed fact here is the director delegated the responsibility to the executive director of human resources and to the executive principals.
But isn't it fair to say that the parties do not dispute that the director did not participate in the decision to not renew this teacher?
This teacher. I think that's correct. However, I would suggest that the delegation to the principal and the executive director of human resources is participation enough in that the director is choosing people who are best suited to make these decisions.
Right, assuming it's delegable, though.
Well, okay, and so let's talk about the delegability issue. Plaintiff cites the rule against delegation. Well, that is a rule that has never been applied to subordinate officials. That's a rule that specifically applies, and I'll quote the City of Rockwood case again. It's a general rule against delegation which forbids municipal bodies from delegating duties that require the exercise of legislative discretion and judgment. That's not all discretion and judgment. Certainly, almost everything the director does, principals do on a daily basis, and the executive director of human resources is going to involve some judgment and discretion. Now, we're not talking about policy making, which is really what the rule against delegation involves. The rule also says it does not forbid the delegation of ministerial, executive, or administrative functions, which really just sums up the idea of what the director's role is. The director is the CEO, the executive officer, and his role is to execute school policy. It's not to make new policy. So the rule against delegation has never been applied to subordinate officials. But even if it is in this case, the role of the director is executive, it's administrative, and sometimes it's ministerial. Thus, any of those duties would be delegable under the rule against delegation. A few other issues. I think the idea that an individual with no authority made the decision, so it's ineffective. I think that is analogous to the Parker v. Lowry case. There, the director did make the decision. However, the director at the time was required to obtain authority, prior authority from the school board before making the decision and sending out those notices. The facts are actually worse in that case. The director was aware of that requirement and ignored it, and made the decision, did not submit to the board, did not obtain prior authority, made the decision and sent out the notices. While the plaintiff there argued, like here, that's ineffective. You didn't have authority to make that decision. You have to ask, you have to get prior authorization from the board. Court in Parker v. Lowry said, no dice. This is a judicial review. You're asking us to go into how this decision was made, and you're a probationary employee, and the purpose of the continuing contract law, again, to sort of hammer that point, it's about notice, and it's about timely notice. And in this case, and in Parker v. Lowry, the court said, you had timely notice. That's all that's required. We're not going to go into how the decision was made. And so in that case, the argument was made, he didn't have authority. But the court refused to go that extra step further, pry open the decision and look into the minutia, which is what plaintiff is asking the court to do here. Plaintiff has also suggested that some of those 37 duties may be delegable, they might be ministerial. Well, that, again, is the rule against delegation. I think we've covered that. But also, how are we deciding which duty is or is not delegable? Which is it, I think Judge McBrayer, you sort of touched on how much involvement is required by the director. Well, at what point is sort of saying grace over a decision that was really influenced by a principal, the person who knows what the needs of the schools are? At what point is that ministerial or executive, or at what point does that sort of cross over in plaintiff's argument? And I think finally, we've talked about the issue of judgment and discretion, and how that's across the board. It's going to be necessary, but it's not legislative discretion, which is, again, what the rule against delegation was talking about. I think I've covered all my points and just under the wire here.
No questions. Thank you, Mr. Puckett.
Thank you very much.
Mr. Colbert, for your arguments.